The court will order supervised visitation if it finds that it's in the best interest of the child to protect the child from potential harm that the child may experience while in that other parent's care. Such harm can result from drug abuse that the parent may have undergone while caring for the child. It could also relate to mental health issues that would impact the other parent's ability to properly care for the child. It could be exposing the child to domestic violence that has occurred while that other parent was caring for the child or in the presence of the child. Any changes to a parenting plan in Florida that's already been put in place require the filing of a supplemental petition for modification. In order to proceed on a supplemental petition for modification, the party must show that there's been a substantial change in circumstances that was unanticipated at the time of the entry of the prior order. In addition to that, the proposed change must also be in the child's best interest. Those cases track very similar to the original proceeding as far as the filing of the petition. You also go through a discovery process that would have been similar to the original petition and the original case that was heard, and a trial date will eventually be set. One thing to keep in mind is that unlike an original proceeding, temporary relief is nearly impossible to obtain unless there has been an emergency that the court deems that it must act right away to protect the children. For the parent that is proposing that the other parent should have supervised time sharing or supervised access to the child, it's important for that parent to present the court with potential people that can supervise the time sharing. In other words, the court will not order a third party or a third party entity to supervise the time sharing. It's really up to the person to propose 3 people that are willing and able to accept that they will be serving in this role. In addition to that, the court will order that the time sharing occur and order specific times, and the court's going to want input from the parties that are going to be delegated to supervise the time sharing. Typically, time sharings that are supervised occur in public places such as parks or other recreational areas or in child-themed restaurants, and are usually for a short amount of time. Oftentimes, a parent will propose that perhaps extended family members that aren't involved in the litigation, perhaps former friends that were mutual to both of the parties, potentially even neighbors. And if that party is willing to pay for it, they may be able to propose therapeutic supervisors such as mental health counselors that are also willing to serve. The biggest consideration for the parent that is subject to an order requiring supervision is to understand that the court is watching and the court will receive feedback of those supervised visits from the person who is supervising. So it's important not to talk about the case with the children, not to use the children as messengers, not to involve the children in litigation in any way. In other words, not to stress out the child or put them in a situation where they may have to feel like there's a loyalty conflict. So it's important for the parent to focus on spending quality time with the child and engaging with the child in such a way that the feedback the judge will eventually receive is nothing short of positive. The court will always implement steps that the parent subject to supervision has to take in order to remove the supervision as a condition of time sharing. That may be successful completion of a rehabilitation program as well as consistent negative drug screens. If the reason for the supervised visitation was due to domestic violence, the court is going to want to see that the other parent has completed the 26-week batterer intervention program and that they participated in that program. In addition, the court is going to want to see that the person has also been receiving appropriate mental health counseling, and if medication was prescribed, the court's going to want to ensure that the parent is compliant with their medication. It's important to have an attorney because you want to be able to tell your story to the court in a way that is concise and in a way that is persuasive if you're the parent subject to supervised visitation or time sharing. You're going to want to present evidence and call witnesses that are going to advocate on your behalf that the reasons that the restrictions were put into place have since been remedied.